Hello, everyone. Welcome to today's debate on the critical question, should states surrender their sovereignty and comply with humanitarian international law? My position is a firm yes. States should, in specific situations, surrender aspects of their sovereignty to uphold humanitarian international law, especially when human rights are at risk. Let me explain why. Number one, first, let's talk about the principle of human rights and the evolving view of sovereignty. Historically, sovereignty was seen as an inviolable shield protecting states from external interference, no matter what happened within their borders. However, in the post-World War II era, international human rights law emerged as a critical framework to protect the rights and dignity of individuals. States, by virtue of their sovereignty, are entrusted with the duty to protect human rights of their citizens. Sovereignty must evolve from a guarantee of unrestricted authority to a duty to uphold the fundamental rights of individuals. This shift reflects the reality that human rights violations like genocide, ethnic cleansing, or systemic torture are crimes against humanity, not just against the state. Therefore, international human rights law should override sovereignty when states fail to protect their people. The idea is simple. Sovereignty exists to protect people, not to shield governments from international scrutiny or intervention. And when states neglect their duties, the international community must step in. This is not a matter of undermining sovereignty, but of holding states accountable to the international norms they have agreed upon. My second reason is the responsibility to protect, which is a legal and moral imperative. This doctrine solidified the idea that sovereignty cannot be an excuse for genocide or massive human rights abuses. Adopted by all United Nations member states in 2005, the R2P emphasizes that states have the primary responsibility to protect their populations from genocide, war crimes, ethnic cleansing, and crimes against humanity. However, if the state is unwilling or unable to protect its citizens, the international community has the duty to intervene. R2P has become a key norm in international law, reinforcing that human rights cannot be secondary to sovereignty. The idea is not to abandon sovereignty, but to ensure it is exercised in a way that aligns with the global human rights obligations. R2P was specifically invoked in 2011 when the United Nations authorized military intervention in Libya to prevent a massacre of civilians by the Gaddafi regime. While the outcome of that intervention is debated, the core idea of R2P was upheld, which is that when a government turns against its own people, the international community has the right and obligation to step in. When we consider that genocide in Rwanda went unchecked in 1994 due to the inaction of the international community, or the ongoing horrors in Syria, it becomes clear. Without R2P and international intervention, sovereignty can become a weapon for oppressors and not a safeguard for the people. A third reason is preventing atrocities and protecting vulnerable populations. International humanitarian law, including the Geneva Conventions and other treaties, exist to protect individuals during armed conflict, but it also extends beyond wartime. It is designed to protect people from state-sponsored violence, ensuring that sovereignty does not become a tool for mass atrocities. We must remember that sovereignty was never intended to justify state-sponsored violence or large-scale human rights violations. It was designed to protect order, security, and the welfare of the population. But when states fail to do so, the international community must act. It is important to consider the Rwandan genocide as an event that might have been prevented if the international community had intervened sooner. 1 million lives were lost, and the international community stood by as the killings unfolded. And this is not an isolated case. Whether it is the ethnic cleansing in Bosnia or the ongoing violence in Myanmar, the failure to protect human rights has tragic consequences. Therefore, humanitarian intervention is not about overthrowing governments for political gain. It is about ensuring that those in power do not use sovereignty as a shield to commit atrocities. The fourth reason is the long term benefits of upholding human rights. When a state violates human rights, it doesn't only harm its own citizens, it harms the global community. Human rights violations lead to instability, migration crises, and regional conflicts. When the international community enforces international humanitarian law, it helps to maintain global peace and security. It encourages states to adhere to their moral, legal, obligations to protect their people, which in the long run benefits both the state and global community. The international community, through legal mechanisms, ensures that governments are held accountable, not for the sake of undermining sovereignty, but for the sake of promoting long term peace and justice. So, in conclusion, I argue that states must surrender certain aspects of their sovereignty when it comes to the compliance with humanitarian international law, particularly when the violation of human rights is at stake. Sovereignty is not an absolute right to act with impunity, but a responsibility to protect the rights and dignity of individuals within a state's borders. International human rights law, backed by the responsibility to protect doctrine, establishes a framework where sovereignty cannot shield governments from the consequences of atrocities. By adhering to these norms, we can ensure that the international community acts to prevent genocide, ethnic cleansing, and other mass violations of human rights. The sovereignty of states should be redefined as the right to protect their citizens, not the right to harm or neglect them. By surrendering sovereignty in cases of gross human rights violations, we uphold a more just, humane, and peaceful world. Thank you.